Good morning. I'm Tom Kimball, Traffic Safety Resource Prosecutor with the Tennessee District Attorney General's Conference. I want to speak to you this morning concerning the new law that goes into effect July 1 called the Recidivism Reduction Act of 2014. This law will most affect judges and probation officers as it is a post-sentencing kind of law. But it's important that you know about it so that you know what's going on and you know what happens if there's a violation of probation concerning this law. The law is Public Chapter 902, and it amends our DUI law in Chapter 40. It applies to second and third DUI offenders, and when it applies to second and third DUI offenders, it is very specific that this is a major change in that in the past treatment only was available for second offenders, and that was the 28 days inpatient treatment. Now, that system that had been in place for a very long time did not work. It's simply that the treatment people unanimously say there is no magic period of inpatient time that is going to change whether a person is going to continue to drink and drive or not. There is no magic 28-day period that says, okay, if he goes in for 28 days, that means he's not going to reoffend. So what was done in this instance is a person, we as prosecutors and you as law enforcement officers will look at this in exactly the same way. As a prosecutor, you don't recommend this or fight against this or deal with this in any way whatsoever other than you go in and you get them convicted and sentenced to DUI second offense or a DUI third offense, and they go to jail. Now, once they're in jail, if they're a second offender, they have to serve 25 days before they can ask or before they can be released with sentence reduction credits for going into treatment. For a third offender, they have to serve 65 days before they can get any sentence reduction credits based on this law. This law, the carrot in this law, is that a person can now go through a drug and alcohol assessment and serve their time, 25 days or 65 days, and then apply to go into a treatment program as is recommended by the assessment. The results of the assessment are given to the judge, and the judge may order a person into a treatment program, or a judge can refuse to do so. There is no right to treatment in this law. So after a person has served a period of time, 25 days or 65 days, and they've had an assessment, and the assessment recommends some sort of treatment, the person can apply for that, and the judge can grant that. Now, if the judge grants that, the judge can also use any kind of monitoring devices, transdermal devices, other types of monitoring, house arrest, and things of that sort, to try to assure that the guy is not drinking and driving while he's out going through treatment. So the judge has all of that, and he can also put on any reasonable restrictions concerning the offender who goes into a treatment program through this law. So if the person goes into the treatment program, the person who goes into an inpatient treatment program will receive day-for-day credit for the time he's in that program. Now that might be, he might be in that program 10 days, or he might be in that program for 6 months. He might be in that program for 25 days, or he might be in that program for 95 days. But whatever he does in that program, he would get day-for-day jail credit if he successfully completes the program. More often than not, I would expect that these offenders would be sent to intensive outpatient. In an intensive outpatient program, they're going to keep the person for a long period of time and monitor them for probably a period of a couple of years instead of a couple months. When they're in that program, the person will receive 1 day of jail credit for every 9 hours in the intensive outpatient program. Typically, an intensive outpatient treatment lasts for 3 hours. So if a person does 3 of those in a week, he will have knocked off a day of jail. Upon successful completion of treatment, if the person still owes us jail time, he has to go back to the jail and complete that jail time. So if he gets 10 days off for intensive outpatient treatment, then he would have to go back and complete whatever he still owes us. Now the stick in this program, told you about the carrot, the stick in this program. If a person does not successfully complete the program, it's a violation of probation. He goes back to court and the judge resentences. The judge can just make him do the mandatory minimum time, 120 days on a third offense, or the judge can go all the way up to the maximum period of time. And the person would get 0 credits, no credits, if he does not successfully complete the treatment program. So if the treatment program calls for him to do 6 months of outpatient treatment, doing 3 sessions a week at 3 hours at a time, and after 4 months the offender says, oh, the hell with it, I'm not going to do it anymore, the person would get no sentence reduction credits once his probation is violated. So that's how this thing is set up to work. It takes effect on July the 1. Any arrest after July 1, this will apply to. If a person was arrested prior to July 1 but convicted after July 1, then that person can opt into this. He is permitted to do this if he is sentenced after July 1. Doesn't have to, but he can. Nothing else is affected concerning fines, costs, license restrictions, or anything else by this law. It's strictly trying to get more people into a treatment process, including DUI courts and drug courts, in order to try to prevent them from reoffending. And hopefully we'll have a little luck with this and we won't have quite as many second and third offenders in the future. For prosecutors, I would urge you not to reduce a second offense to a first or a third, or that's the main one. Don't be reducing cases to knock them out of this program and allowing them to simply do 48 hours on a first offense if he is in fact a second or third offender. We know that these convictions matter. We know that this type of treatment can have an effect. We know that this can work because we've seen it work in a lot of other states that are doing this type of thing. We did not create this wheel. But it won't work unless we hold people to it and unless we get people into the program to start with. We hope that it'll make a difference in that offender's life so that they won't be reoffended and we won't be dealing with them again. But we also hope that it's ultimately going to save lives on our roadways because they won't be drinking and driving or be as likely to drink and drive as they were in the past. Thank you.